Okay. So hello, everyone. As Lori said, I'm Katherine Dowle. I'm the Senior Area Director here at Legal Aid. Just to give you a little bit more information about myself, Lori's correct. I got my call to the bar here in Manitoba in 2005. Before that, I received my law degree at Robson Hall at the University of Manitoba in 2004. I did practice in private firms for a couple of years and then came back to Legal Aid in 2008. I had actually articled and done some summer work with Legal Aid prior to that. And so I practiced as a criminal lawyer, doing also some work in child protection for a number of years. And then in about August of 2020, I believe it was, I joined senior management, and I've been here ever since. So just so you're aware of a little bit more about who I am. So I'm here today to talk to you a little bit about Legal Aid, what it is, what we do, how we try to do it. So I'm going to go through a PowerPoint and kind of talk as I go through it and give a little bit more information outside of each of the slides that I have on here on a PowerPoint. So to start out, who are we? Legal Aid exists as a result of legislation called the Legal Aid Manitoba Act. We are actually a branch of justice, but we're not actually controlled by justice. So the act itself is available online if anybody wishes to see it. All Manitoba legislation is available through a website with the province of Manitoba. So the act is there, the Legal Aid Manitoba Act, as well. Our regulations are online through the government of Manitoba. And so really the act kind of gives us our authority, and the regulations sort of outline how we put this into practice. So as the slide says here, we are a branch of justice, but we're not actually controlled by justice. We're what's considered arm's length. And what that kind of means is that there are groups such as Manitoba Prosecutions or Public Prosecution Services of Canada. That would be by short terms known as the Provincial and the Federal Crown Attorney's Office. So we're sort of under the same umbrella as them, although we are not controlled by government in the same way that those groups would be. We are independent of government, and sometimes we are actually doing things that's government might not even like, but that's what we're here to do. So if anybody is interested, as I said, all of that legislation is available online, and you can go and look at that anytime you want. We also have our website, so it's www.legalaid.mb.ca. Now, our website has all of the information that I'm about to talk about, and as well as a lot of other information. There's information on there for lawyers specifically, but there's also information for the public. So you can feel free to go to our website and browse it and see if there's any information that you're looking for there. Certainly, if you're unable to find the information, I'm going to go through some contact information for us, so you can contact us at any time, and we'll be happy to help in any way that we can. So our mandate is really, the overreaching umbrella is delivering access to justice. The Legal Aid Manitoba Act has certain requirements from us, and the mandate is a four-part list here. The first part is to provide quality legal advice and representation to eligible low-income Manitobans, individuals, and groups. We administer the delivery of legal aid in a cost-effective and efficient manner. So we're required to kind of watch our pennies and make sure where we're spending them and that they're spent well. We had provided advice to the minister on legal aid generally and to the needs of specific low-income individuals. So we're kind of a connection between the government and the people on the street, so to speak. The needs of individuals change constantly, and the government is not necessarily aware of what those changes are. We try to be aware of those types of things and bring that information to government so that we can provide the services that are required by individuals. The fourth one is to fulfill the constitutional obligations of the province to provide defense counsel in criminal matters, child protection matters, and there are other matters as well, in an efficient and effective manner. And for example, what that kind of means is constitutional obligations are things like, for example, under the Canadian Charter of Rights and Freedoms, you have the right to retain and instruct counsel under Section 10B of the Canadian Charter of Rights and Freedoms. And so what that means is that we have counsel, duty counsel, available for people 24/7. So, for example, if someone's arrested at 3 o'clock in the morning, they can call and get legal advice at 3 o'clock in the morning. So people are available 24/7 to assist in that regards. That's just one example, but to kind of give an idea of what we're talking about there. So we service clients through what is called a mixed model. That means there's staff lawyers as well as private bar lawyers in the community that assist us to be able to provide these services. I'm just going to move to the next slide here. So what that means is private bar staff and our staff lawyers. Private bar means people that have their own law firm, for example. It's a private law firm with a number of lawyers in it. All of them, some of them may do some legal aid work. So what that means is they contract with us through a certificate, and we'll talk about those in a little bit, to do legal aid work. So private bar lawyers can have legal aid clients, but they can also have private clients who are actually paying legal fees directly to the lawyer. Staff lawyers are lawyers that work only for legal aid, doing only legal aid work. So Legal Aid Manitoba has 8 offices in Winnipeg, and then we have 4 offices located in rural jurisdictions, Brandon, Dauphin, The Paw, and Thompson. Now, all of these courts cover, for example, a number of services within each of their jurisdictions, but they also cover a number of circuit points. So these circuit points mean small areas that hold court within their community. So often that could be a very remote area that holds court in a community hall or a band hall. Lawyers will fly in. There's some circuits where it's like planes, trains, and automobiles. You'll have a small little plane that you fly in, then you're on a hovercraft or a helicopter. I've gone to court on snowmobiles. So there's a number of creative ways to get the lawyers to those small areas. But we do cover a number of circuit areas throughout the entire province. Overall, there are about 300 private bar lawyers that do legal aid work. And there's about 50 staff lawyers throughout all of our offices that are doing some of this work. So sometimes these lawyers the private lawyers can be under a contract. So the private bar lawyers will have contracts, or they could be under what's called a certificate. So what a contract is perhaps there's certain areas that we don't have staff to be able to cover them. We will have a contract with individual private lawyers throughout the city to provide the work that is required in those particular jurisdictions. So it could be a small community. We just don't have enough lawyers to cover that. So we'll create a contract with a private lawyer to provide those services. And again, our staff cover whatever they can, but there are a lot of areas throughout the city that require our services. Excuse me, I'm just going to flip to the next. There we are. So the types of services that we deliver, there's a few different ways that they can be delivered. So by formal representation. So that would be when we provide a lawyer to deal with a particular legal issue. So this is something where we would issue a certificate to a private lawyer or to a staff lawyer. They also receive certificates to cover a particular matter. So that could be a criminal charge or a family matter, something like that. We also then have duty counsel services. So that's sort of initial information and advice at either an early court appearance, or as I mentioned, when somebody's arrested at 3 o'clock in the morning, they can get advice for that particular situation, be it a criminal charge, and what they should do. Generally, the advice is don't talk to the police, but each case is individual. So the services can be provided either in person or by telephone. And they're provided, again, when a person's detained or by a police or some sort of similar agency. So Legal Aid Manitoba is limited to providing services within a specific range. And this is a lot of confusion comes from this because people hear the name Legal Aid and think we just cover all issues that people may have that have legal ramifications. That is not the case. We have a limited amount of funding that we receive every year, and we have to provide services within that funding amount. So because of that, we've had to sort of limit what we can and cannot provide to individuals. The specific types of matters that we do cover, family law, criminal law, and that's for both adult and youth matters, child protection matters, and we'll act in those matters for both parents or children themselves. There's immigration and refugee matters. That's mostly dealing with deportation and, again, refugee claims. There is mental health detention. That's when somebody is held involuntarily in a hospital when they're suffering some mental health issues, or perhaps not. Then that's the kind of thing that we want to look into. There's residential tenancies, which is generally dealing with people in a position of being evicted from their homes. There's government benefits. So that's matters where EIA, which some people will call social assistance or welfare, that's employment and income assistance. Say somebody's been cut off from their benefits. That's the type of thing that we may be able to help them with. As well, we have public interest. Now, we have a public interest law center and the PILC office, and we'll just talk a little bit about PILC in a nutshell. Now, PILC can be a very complicated thing. It's the only group within all of legal aid that covers a lot of things that are not generally covered by our other offices. They represent groups and individuals on issues that are affecting things like the environment, human rights, Indigenous peoples, consumer law, as well as low-income persons. So again, they're a very specialized unit. They have their own criteria that we're not really going to cover today as to what they can and cannot cover. They've been involved in a number of very interesting things previously. They have a very small and very dedicated team that work with other private bar individuals and other stakeholders to provide the type of work that they do. And just for a little bit of an example with PILC, they've previously been involved in things involving, for example, hydro rates with Manitoba Hydro. They have been involved in environmental issues. For example, they back in 2015 got involved with the Manitoba Law Reform Commission when there was some very wide-ranging changes in the Manitoba Environment Act. So because of the work that PILC has done, they now, within that legislation, it provides for a greater role for public and Indigenous input, and that's things that we did not have previously. So again, I'm not going to go a lot into the Public Interest Law Center, but they are a very, very important part of Legal Aid Manitoba. They're a little bit independent, as I said, and they have a lot of their own rules. But I just wanted people to be aware that the Public Interest Office actually exists and that they can sometimes help people with things that are outside of our usual mandate. So going a little bit into legal aid generally outside of PILC and what it is we do and how you can qualify for it. There's two things that legal aid is really looking at when we get an application from a client. The first one is the financial qualification. The second one is whether or not there is merit to issuing a lawyer to assist that person. So we'll get into a merit in a few minutes here, but first is the financial qualification. On the screen here, you'll see what is our guidelines, essentially. Though it talks about the first column is the family size and the second column is the free legal aid, and we'll look at that to start with. So what is a family size? So a family unit is what we call it. And that would be yourself. If you don't have children and you're completely on your own, you're not married, you would be a family unit of one. Okay, if you have yourself and you have a couple of children, 2 children, you would be a family unit of 3. Now, if you have yourself and you have 2 children, but you share them with your ex for 50% of the time, well, we would give you credit for 50% in that regard. So it would be yourself and 2 children 50% of the time would make you a family unit of 2. So it can be a little bit complicated in that regard, but we assess each and every application based on the information that we are provided. And then we take a look at your income. So from that, some people are on EIA. That's easy to assess. When people work, we would require copies of their pay stubs. We ask for the most recent 3 pay stubs, or even a letter from your employer outlining what your gross family income is, and that's before deductions. So a family unit of 1, the rate is as long as you make less than $26,500, you fully qualify for legal aid. A family unit of 2, as long as you make less than $33,000, you fully qualify for legal aid. Now, these amounts, I agree, it seem low. We've based these off, you've noted in the 4th column here, the poverty line. It's the cutoff is what's called the LICO. It basically is a government amount set up that we follow. So LICO is what a lot of this has been based off of. Now, the second part would be the agreement to pay program, and I'm going to get a little bit more into that later. But what the agreement to pay program is people that are over the base amount. So you're a family of one and you make a little bit more than $26,500. As long as you're less than $38,500, you can qualify for the agreement to pay program. And what ATP does, we call it for short, and I'm going to just flip to the next screen. This is an agreement between the client and Legal Aid Manitoba, in which the client receives the full legal assistance from Legal Aid Manitoba, and they actually have to reimburse Legal Aid for the costs. Now, those costs are under what's called a Legal Aid Manitoba tariff rate, and I'll talk about that in a little bit. So it's, I can say, a lot less than what a private lawyer would charge someone. So they basically file an agreement with Legal Aid. It is actually offered to applicants whose income, again, is above the guidelines, but low enough that they're not actually able to pay for a lawyer. So lawyers can be very expensive. So the way that works is a client would make an initial payment. And the initial payments range anywhere from $400 to $700, depending on what type of matter it is that the person's applied for. And then they would make monthly payments after that are generally $100 per month. So the final total costs of the file are set out based on our tariffs, and I'll talk about that in a little bit as well, but it's a set amount for each type of legal matter. So in the end, once the lawyer bills out the file, we hope at that point that the client, having made monthly payments, has got money in their, what we call a bank, and that there's enough in that bank that they can repay the full costs of the legal matter. And if there's any money left over, of course, after we've gone through our accountings, we would return any extra money to the client. And if there's money owing still, despite the fact that the client's legal matter has been completed, we do still expect that the client continue to make payments until the full costs of their file have been paid off. So one other thing that we do look at as far as recovering costs on matters is what's called a charge on land. So what that is, it's a sort of a special lien against the applicant's property if they have an interest in land. It secures the costs, again, of representation similar to ATP repayment. And so these costs are taken, though, out of the person's interest in a property. So what that means is you apply for legal aid and we notice, hey, you own a property, whether you're on title or not. So you may have married someone who owns a home. If you've lived together in that home, you, even though you're not on title, may still have a legal interest within that property. So legal aid in that case would then file a charge on land, or a COL, we call it for short. So what that does is it sits on the person's property. Now, legal aid would never make someone sell a property to recover costs. What we do is we just leave that on there, and I'm just going to flip to the next slide here for you. So the individual, it's condition precedent. They must agree to a charge on land if they have interest in a property. We will not actually issue a lawyer to someone until they have agreed to the COL. Now, the important thing is, though, we would never, ever force someone to sell a property to recover costs. And as well, if someone had to refinance a mortgage for the purposes of paying off debt or things of that nature, if there's funds available, we would expect repayment on our fees. Having said that, there are exceptions to that. We obviously would, on a case-by-case basis, be prepared to sort of defer our charge on land on a refinance of a mortgage. Now, if someone sells a property, say at the end of a divorce, and the parties have agreed that the property is to be sold, our lien then secures our costs, and the cost would be repaid from the sale of the home. The most important thing to remember from here, though, is, again, legal aid would never force someone to sell a property to recover costs. So we will have liens that will sit on properties for 20 years. I'm not sure if there's limits on that, how long it goes for, but we will leave charge on land for forever, essentially, until the property is sold one way or another. So that's sort of the piece on how we determine whether someone financially qualifies. Each case, again, is a case-by-case basis. We will look at it. We sometimes have perhaps difficulty when someone is, for example, self-employed, they own a small business. So there's different things that we will need from the client to be able to confirm what their gross family income is. we will send letters to the client asking for additional information. When people apply, they usually don't realize what it is that we're actually going to need from them. So there is a bit of a back and forth with the clients to make sure that they've provided whatever we need. And if anyone has any questions, they can just call into our application center. I'll talk about them in a moment. And we will make sure that we have all the information that we need to assess someone's financial qualification for legal aid, be it for full legal aid or for the agreement to pay program. So that kind of explains that a little bit. Now, moving on to legal merit, and this is where things can get a little bit complicated. Legal merit doesn't mean that it's not a good case. Okay, sometimes legal merit, we have a very set consideration for legal merit. We have what's called our area director's manual. And again, that is available online at the address that's provided here. It's as well, there's a link to the area director's manual and a lot of other very important documents through our website. So again, that's the www.legalaid.nb.ca. There's a site there that's called links and downloads, and that would bring you directly to a copy of our area director's manual. Now, this is something that sets out what merit means when it comes to criminal matters or family matters, and it's different for each and every type of legal matter. Now, for example, on a criminal matter, one of the main considerations for us is there a risk of jail for an individual? So if someone's liberty is at stake, that would technically be something that is meritorious. So as long as the client financially qualifies, and we've already gone through the financial piece, merit, if there's a risk of jail, chances are there is probably going to be merit for that, and that would be something that we would issue for. Now, there are a number of other considerations, but criminal risk of jail is one of the main things that we're going to look at. Now, if somebody doesn't have a risk for jail, say they've got a first offense impaired driving charge, there are some things that we need to look at in that regard as well. There is a potential, some people, depending on the circumstances, could be, if they're not a Canadian citizen, for example, could be looking at deportation as a result of that. So even though there's no risk of jail, deportation is something that's very important. So we would, chances are, issue counsel for something like that, as long as we have that information and we're able to assess that the person is not a citizen and they could be looking at deportation. There could be another situation where if you don't qualify, because there's no risk of jail, we have other partners. For example, the University of Manitoba. We will sometimes make a referral to the U of M, and they may be able to assist an individual who is not looking at a risk of jail, but again, they have a criminal charge and they need some assistance with that. So there's a number of different considerations that are all happening at the same time, but we do assess each and every application for these types of considerations. So when it comes to family matters, that can be a little bit more complicated. So a family matter, we will cover things like divorce, child access, child custody, spousal or child support. One of the considerations in that regard, though, so if we have, for example, an individual who is married for 30 years, they've had a couple of children together, and the children are all grown and moved out and even have children of their own at that point, so there's no children involved, and we have this couple after 30 years to decide they're splitting up and they would like to get a divorce. Okay, so they apply to legal aid. Well, divorce technically is an area that legal aid will cover, but there are some rules relating to divorce. Individuals need to be separated for a period of at least 1 year to even apply for a divorce in Manitoba. So if you just split up 2 weeks ago and you've applied for legal aid, and the only issue is divorce, chances are we may reject that and say to you, well, come back and talk to us when it's closer to 1 year having been separated. Now, again, there are exceptions to that. Sometimes a divorce can be granted when the parties have been separated less than a year. If there was issues, say, as cruelty, for example, nobody wants to force someone to stay together when there was significant cruelty within the marriage. So again, that's a consideration for them. Now, things can get a little complicated, and I know sometimes clients are unsure of what's happening when we've rejected a file like this. So when you have this same couple that has a 30-year marriage with no issues regarding child support or child custody, the only issue is divorce, and the one party wants spousal support. So say, for example, it was a situation where Both parties worked throughout the relationship. So say the husband works, he earns more money than the wife, but the wife worked as a registered nurse for the entire relationship. The children were in daycare. Both parties worked throughout the entire relationship. Well, in a situation like that, our area director's manual, and we would look to what's called chapter 5.3.1, and under sub D of that, spousal maintenance alone, when it's sought by a wholly dependent spouse or common law partner in a long-term traditionally dependent role. So that's what we're looking. There's legal merit if those criteria have been met. So in the scenario I gave you, when you have two parties, the wife in this situation, say she's trying to seek spousal support, she was not a wholly dependent spouse in a long-term traditionally dependent role because she worked throughout the entire relationship. So in that case, that is something where we may not cover divorce. So it can be very confusing. Again, all of this information is set out in our area director's manual. And we ourselves have to refer back to the ADM, we call it for short, on almost a daily basis to remind ourselves of what is the criteria, what is it that we're looking at, and how is it being applied in each particular case. So domestic merit, again, can be very complicated. So our intake department, and we'll talk about them a little bit later here, they're the people that will take your application from you. They are specifically trained, and they will ask the client and the applicant specific questions to try to answer some of the questions that we will come to when we're trying to assess legal merit for a matter. So it gets confusing because when you say legal merit, it does not mean that you don't have a decent claim or that we're in any way saying that it's not important. But legal merit means something very specific to legal aid, and it just means the criteria that is outlined in our ADM. So that's just a couple of examples about how that works, so that people are aware. And again, if you have questions, you can always contact us, and we will take a look at each and every case individually. So moving on now, legal merit continued here. Where possible, legal aid does try to avoid duplication of services. And this comes back to our mandate where we're supposed to provide cost-effective services. So for example, where somebody wants to recalculate child support. So I've got an order and it says that my ex has to pay a certain amount a month for child support, but now I've gotten information that I think that they're receiving more money and I think that my child support should be increased. Well, there's a service called child support recalculation services that do that exact type of work. Again, it's case dependent, and there are some times where the court has specifically said that it can't go to child support recalculation. But if possible, we will reject a client's application and tell them, you should probably go see child support recalculation. Now, if a client's done what we've said, gone to child support recalculation, they have refused to help them for whatever myriad of reasons, they can then come back to us, and we would always reconsider if the suggested referral is not something that's going to work out for the client. So we can always reconsider a rejected application. Another one would be, for example, CLIA. We will not try to duplicate any work that CLIA is able to do. Mediation services. There's also a place called the Legal Help Center, or as well as I mentioned, the University of Manitoba. So we all do something slightly different. We're all trying to work from a very small pot of funds that are available for us. So duplicating work is what I would consider a waste of money. So we very much try to work around that and make sure that there is at least a place that will provide the services that are needed, but we, again, try not to duplicate them. As well, if we've noticed a systemic issue, that's something that we might refer to the Public Interest Law Center. Again, if they financially qualify and we found merit. The Public Interest Law Center, though, has its very own set of criteria as to what merit might be. So they will do their own assessment of each case that we refer to them, and they will let us know whether or not the case does meet their criteria, and it's something that they think that they can assist people with. So that's often some much larger issues that go well beyond staff counsel or private lawyers doing certificate work. So just so people are aware of that. Okay, so how do you apply? There are a few different ways that you can apply for legal aid. I myself am also in charge of our intake department. In addition to the duty counsel and child protection offices, I am responsible for intake. So what that means is we have intake officers that are highly trained, and they are the people that will take your calls. So you can, first of all, apply in person. So if you had a criminal matter and you're in court and there's a lawyer there, they can take an application for you right then and there. Secondly, in a lawyer's office, you could attend to a specific lawyer you'd like to have represent you on your matters. They can actually fill out the legal aid application and send it in for us. We then also can take applications online. And again, that's under our website that I've already talked about. You can find how to apply online. Now, if you do apply online, you're filling in your own legal aid application. It will tell you at the end of that application, you are still required to call in to have your application verified. And what that means is our intake officers will quickly go through the information that you've provided and ask additional questions about things that we're going to need to know about that will delay things if we don't have it. So they're going to make sure that all the information is in there. They're also going to go through a number of what we call an attestation. There's some rules that go around legal aid and what you're agreeing to by signing a legal aid application. So they'll go through all of that just to make sure that the client is understanding what it is you're agreeing to. And that could be something as small as it gives us permission to advise a judge, not a Crown attorney on a criminal matter, to advise a judge the status of your application. So you've applied and it's waiting for your police reports to come in so we can assess legal merit. And that might take some time. So a judge may want an update on that. The legal aid application gives us authority to provide that update to a court, not to anyone else but the court. So we do take privacy very, very seriously. And like I said, we just want to make sure that the clients are aware of what they're agreeing to when they've signed a legal aid application. So another way to apply for legal aid, and the most popular way, is to do it by telephone. Now, this is something that we had been working on for a long time. Once COVID came around, we sort of pushed this forward and had our online application center, our telephone application center, what we call the BATS line. That's BATS. It's the Bridges Automated Telephone System. So people can call in, and we've provided the numbers here. There's 204-985-8511 is the number to call for local within Winnipeg. We also have a toll-free number for anywhere else within Manitoba at 1-866-800-8056. Now, what happens there, and this is Monday to Friday, 8:30 to 4, we will take telephone calls from people. The intake officers will help the individual fill out the entire application, go through the rules with them. And again, everything that you're agreeing to, they'll read all of that to the client. We will make any kind of accommodation. We have lawyers that are available to assist, for example, in different languages. If there's some sort of a physical disability, we are prepared to do whatever it is that we can to accommodate each and every client and any needs that they might have. So be it that different language, sign language, interpreters can be provided to take an application. We want, again, access to justice. So we don't want someone to be missing out because they're having a difficulty because they have a physical disability, for example. If you don't feel that you can fill out an application by telephone because you've got issues with hearing, we can take applications in person. So we will do whatever we can to assist a client to make sure that they're properly able to apply for legal aid, and in a way that is working for them. So we try to do whatever we can in that regard. So again, as soon as an application has been filled out, our intake department will then go through, assess the financial eligibility and the legal eligibility, so the merit of each and every application. And as I said, the intake officers are highly trained. They know the area director's manual like the back of their hand. They are well aware of the types of things that we do or do not cover. Now, what will happen, a legal intake officer will assess, for example, legal merit on a file. And if they've come back and said, no, I don't think there is legal merit, then the application will be rejected by our area director. So that's the level that we have 2 area directors in Manitoba, one that covers only the northern, the Thompson and the Paw areas. And then we have our main area director, Lori Anderson, who actually is the area director for the rest of Manitoba. So at that point, the intake officer will be at Lori's level looking at it, and they would reject an application for whatever it might be. There's no legal merit, say. The client has a right to appeal that rejection. So what ends up happening is the information is provided to the client on how to appeal. That goes with the initial rejection. In the end, they can appeal, and appeal will come to my level. At that point, I will reassess what the decision was, why the decision was made, and if the decision was in fact accurate. Now, the client can provide additional information at that point. If there's more things that they think that we should be considering, we are open to receiving any and all information from the client in order for us to reassess the rejection at that point. I can then make my own decision, and I will usually send a letter to the client that gives a lot of detail about, for example, if someone was rejected for financial eligibility, you make too much money. So my letter will go through in detail how we calculated your income, what the income levels would be, so what the level would be for full qualification for legal aid, and what the level would be for the agreement to pay program, and why it is that we've assessed that you exceed that, and why we rejected it. So it gives a lot of detail to the client to be able to make their understand what it is and why we've actually rejected them at that point. So people then have the right to appeal me. So my letter itself will tell them, look, you have still the right to appeal my decision. And my decision gets appealed to what's called our appeal committee. And that's a group of individuals who are outside of legal aid. They then receive a package from myself. I will write the whole thing up into a memo and send it to our appeal committee. And then they will independently look at the decisions that were made by the area director, by myself as the senior area director, and decide whether or not it's accurate. They can make some exceptions sometimes, depending on the circumstances. But at that point, if they have made the decision that we were correct in our decision making at the lower levels, then they will send a package to the client explaining to them what they've done, what they've reviewed, and the decision that they've made. Now, at that point, there would be no further right to appeal within Legal Aid Manitoba. If a client wished to appeal something further, that would be done by way of a judicial review in a court of law. So that is not something that we would cover at that point. So that, for the most part, covers really legal aid, what we are, what we do. I know this presentation is quite a bit shorter than the last time I was involved with this. We had a family lawyer with us that was also answering some questions here, but I think we still have about 15 minutes left. I don't know, Lori, if you want to open the questions now and see if anyone has any questions specifically that they would like answered, or if there's anything I covered that people would like more information about.